I am Jennifer Granick. I'm a lawyer. I'm the executive director at the Stanford Law School Center for Internet and Society. And I teach a clinical class there called the Cyber Law Clinic. And I also teach a computer crime class, which I think this year we're calling the Computer Crime Seminar, which I co-teach with Richard Salgado, who is in the General Counsel's office at Yahoo now, but is formerly with CSIPs at the DOJ. So I'm going to sit for my presentation today. I hope that's all right. And what we're going to talk about is the interrelationship between intellectual property law and vulnerability research and reporting. Okay. So, can you guys over there see me? Is this all right? No? All right, I'll stand. If I get tired, though, I'm going to sit. I don't want to cheat this side of the room. Okay, so I'm especially looking forward to this talk today for a couple of reasons. One is that I wrote a chapter for an O'Reilly book that's coming out called Security Power Tools, and my chapter is about these very issues. It's the first time I've ever published something that's amalgamated into book form, so I'm really excited about that. And I think it's supposed to be out in August later on this summer. The second reason I'm really excited about this talk is because I am announcing that I am leaving my job at Stanford and going to work at the Electronic Frontier Foundation to be Civil Liberties Director there. Thank you. The basis for that decision was that I decided that, at least at this point in my career, I wanted my mission to be not so much to make better lawyers, but to try to make better law. And I'll have more of an opportunity to do that and work on the issues that I like to do while at the EFF. So I'm excited about that. I have my new business cards and I have my new contact information on the slides later on. Okay. So what I want to do today, and the approach I want to take, is I want to take a kind of case study method and look at two instances where intellectual property law has been used to go after security researchers, and use those as case studies to kind of illustrate and hopefully illuminate some of the complicated issues in this area. Okay. The first case I want to talk about is Cisco and ISS versus Michael Lynn, which some of you may remember from this BlackHat 2 years ago. And this is a situation where a researcher wanted to do a talk here at BlackHat about some security vulnerabilities he found in Cisco routers, vulnerabilities he had found while an employee at ISS. And the companies tried to stop him from making this presentation, and he quit his job, went ahead, made the presentation anyway. They then filed a lawsuit against him and also BlackHat for copyright infringement, misappropriation of trade secrets, and breach of contract. And I represented Mike in the civil aspect of that case. I have two URLs up here, which are links to my elongated story about the ordeal and the pleasure that it was to work on this particular case. And I'm also going to talk about HID versus IOActive, which happened at BlackHat Federal earlier this year. It's amazing how BlackHat just attracts these kinds of legal complaints, isn't it? It's kind of great. And in this case, some security researchers who had been doing work on RFID tags and had developed a way to spoof RFID tags to show that the technology is not secure, were threatened in a letter with a patent infringement claim. And I know that from having been involved in the case, and maybe there's some people from HID here in the audience, that the company claims that it didn't really threaten them and it wasn't really claiming patent infringement or anything like that. But I have seen the letter that HID sent to IOActive, and in the letter they say, based on our understanding of how your spoofer works, we believe your conduct may constitute direct infringement of HID's patents under 35 U.S.C. 271A. It lists some patent numbers, and it asks them to not publish any of the information. The result in that case was a bit different. HID did change their, IOActive did change their presentation whereas Mike Lynn went for it and ended up getting sued. So using these two cases, what I want to talk about today is copyright infringement. It's the relationship of the infringement law to the practice of reverse engineering, and whether the fair use doctrine saves reverse engineering for security researchers. I want to talk about trade secrets and how trade secret law and reverse engineering interact with end-user license agreements, terms of service, and contract law. And I want to talk a little bit about patent infringement, which I'll just tell you right off the front is something I know extremely little about. And then finally, sort of the overall question and problem of free speech and vulnerability reporting and how they go together. And we're going to do all this before 12:30, and I'm going to take your questions as we go. So let us proceed. Okay, copyright infringement in this case. Basically, in the Lynn case, one of the major claims was copyright infringement, and the copyright infringement claim wasn't particularly interesting. Okay, the copyright infringement was mostly based on the idea that the slides that Mike Lynn had for his talk were the slides that he had developed while an employee at ISS, and that these then were ISS's intellectual property, not Michael Lynn's intellectual property. It's not particularly interesting, and it's depending, I don't know what the slides look like, but the thing that this claim illustrates about copyright law is that copyright law protects original expression. It doesn't protect facts or ideas. So it protects original way of expressing facts or ideas. So if you have facts sort of in a list, you can't really protect it. You can only protect the way you make the list in some kind of original sort of fashion. Oh, I have a question already.
But I get kind of disheveled when it becomes compiled code. Has there been discussions about that?
Yeah, so the question is source code and compiled code, how does copyright law treat those? And copyright law protects both source and binary and machine code. It protects both. And, source code's kind of obviously, for those of you who are programmers, you know that there's some amount of art that goes into writing it. But copyright law protects the compiled binary as well. And that's actually kind of good, right? Because one of the arguments we often make in other kinds of cases is that code is speech. Code is not just functional, it's actually an expression of ideas that computer scientists and other people can understand, and that it should be protected, or at the very least that First Amendment and free speech principles should come into play when we're talking about regulating code. So you can understand how on the one hand, if we're going to say code is speech and code deserves some sort of First Amendment protection, on the other hand, we're also going to say that's because it's original, and if it's original, and expressive, then copyright law is going to come in. The amount of copyright protection is going to kind of be on a scale, though, right? So something that's more factual and less expressive could still be protected, like, maybe a news article, and something that's extremely on the creative side and is all, originality, like very few of our Hollywood movies today, those things would be kind of on the upper scale of protection. So it's a sliding scale, but it's within the realm of copyright protection. So the slides, in many ways, I hadn't seen the original ISS slides, but we're imagining if you're talking about slides, you're talking about facts, and they're not particularly. Most people's PowerPoint slides are not particularly expressive. My boss, Larry Lessig, is a kind of notable example of the opposite of that. He has very expressive PowerPoints, but I'm still laboring in the dark ages of PowerPoint use. So. The second copyright claim that they made was in the decompiled code for the Cisco source code. And certainly Cisco has copyright in the source code, as we just discussed, and in the binary too. And it probably has copyright in the machine code as well. If we're going to say, well, software is protected, it's going to be protected in all of these iterations. But what Mike Lynn did was he just used sort of snippets of this code in order to illustrate the points that he was trying to make about how he found the vulnerability and why it existed. So the question is, can you use some of these snippets of the code? Is that okay? All right. So Copyright infringement protects software. When copyright law is protecting something, it gives the owner certain exclusive rights in the work, even though I distribute it or sell it or something like that. And those rights include the rights that I have up here, which I'm not going to read, but the rights are limited, right? They're enumerated rights that the owner gets to hold on to. And on the countervailing side, we have the rights of the public, and some of these are specifically statutorily identified. So one part of the copyright law says that it's okay to modify a program that you yourself legitimately own, right? So program mods are okay. That's sort of a little bit narrow. You see, you can reproduce or change the program if the reproduction or adaptation is necessary for the program to be used in conjunction with the machine. So if I buy something and it's kind of obsolete and I want to modify it, or if I want to get some other kind of program and I want to make them work together, I'm allowed to do that under Section 117. And then we have the question of reverse engineering and what we are allowed to do there. So reverse engineering is generally protected by the fair use doctrine. And I've listed the 4 elements of the fair use doctrine here. So let's just talk a little bit for a moment about fair use and what fair use is all about. Fair use is a defense to copyright infringement. We often think of it as a right, sort of a right of public access, but it's got this kind of tenuous nature. Is it once you've infringed, you have this defense, or is it something that members of the public are entitled to do and is like sort of something that really needs to be protected in a much stronger way, like some of our other kinds of rights? And in our law in the United States, we have this kind of fuzzy 4-factor test where the judge sort of weighs all these factors and tries to determine whether or not something is fair use. It's not necessarily the way it has to go. In other countries, they have like a list. They just have this big list, and it's like, you can do this, you can do that, you can do the other thing. And the list is exclusive. It's like, do those things, other stuff we're not going to consider. That stuff's not fair use. So one of the nice things, and this is something that for those of you who consider the law or who are lawyers know, one of the nice things about a fuzzy test like this is it's so flexible, right? It gives you like room as new technologies come up or things evolve. You've got this great flexible test that can take all these factors into consideration and can evolve, right? Things can sort of change. The thing that's not good about a flexible test like this is that nobody has any idea what the hell is fair use, right? You don't know until you go ask a judge, and as we know, judges differ on these issues. So this is really hard for business people or for companies who are trying to make assessments about, or artists who are trying to make assessments about, am I well within the fair use doctrine, or am I kind of skirting on problems here? Am I going to get sued? What's going to happen to me? What will the judge say? And they don't, people don't really know. So you can have something like the book, The Wind Done Gone, which is a sort of takeoff critique of the Gone with the Wind story written from the perspective of one of the slaves on the plantation. And at the trial level, the court said this is not fair use because it's taking the Gone with the Wind characters and the Gone with the Wind story and it's making a derivative work which is infringing. Only the copyright owner has the right to make Rocky 18. So, only the Margaret Mitchell estate has the right to authorize sequels to the Gone with the Wind story, and this is one of those. The Court of Appeals, other judges disagreed, and they said, no, we think that this is, sort of a parody. They're taking elements, but the elements are to critique the original work, and it fits in under these standards. So, that's a great result for fair use, but they lost first, so who knows? It's not necessarily clear. Okay.